All versus Wesley Financial Group, LLC.
Good afternoon, Your Honors. John Quinn of the Nashville Bar, here on behalf of the Appellant, Wesley Financial Group. I would like to reserve 3 minutes. For
3
rebuttal.
minutes, okay?
Your Honors, the trial court's judgment in favor of Audrey Korshoff, the plaintiff appellee, should be vacated and remanded for a new trial because the trial court entered 2 mutually exclusive verdicts and failed to perform a proper 13th juror analysis. As it relates to the breach of contract and unjust enrichment, the request for a new trial is based upon the existence of inconsistent verdicts. As the Tennessee Supreme Court has said, an inconsistent verdict is a nullity. Milliken versus Smith, the Supreme Court said inconsistent verdicts can't stand. So the question is, are the verdicts inconsistent? A breach of contract verdict and unjust enrichment verdict are inherently inconsistent.
Counsel, why doesn't the trial judge's temporal explanation reconcile those two? And the trial judge seemed to be tying this to breach of contract is for a certain time period and unjust enrichment is for at the end of the termination of her job, the continuing accrual of leads that came to fruition. Why doesn't that reconcile this?
Well, it doesn't reconcile, Your Honor, because that's not the law in Tennessee. That's never been the law in Tennessee. There were no cases in Tennessee that have held that on a case like this, where we have an employee who is suing for unpaid sales commissions, who has a contract, an employment contract with Wesley Financial, who's then admittedly fired. She sued for unpaid commissions. She offered no services. Under unjust enrichment, if there is an enforceable contract, then you don't get into the quasi-contract, the unjust enrichment arena. You can't have it both ways in Tennessee. If there's a contract, then the contract governs. If there was no contract...
Well, but is it truly that absolute, though? I mean, it seems like to me that part of that rule is the contract has to cover, and I can't remember the exact wording here, the same general subject as the basis for the claim. So you'll see cases say generally you cannot have unjust enrichment and a breach of contract claim. And that's because sometimes you can, right? I mean, there are some instances where you have a breach of a contract, and then there is some other independent basis for unjust enrichment.
Sure, and I would say, Your Honor, to that is true, especially, for an example, in the construction arena, where a subcontractor would have a contract with the general, but obviously not a contract with the owner. So in that instance, if he's not paid by his contracting partner, his privity of contract partner, the general, he has a breach of contract action against his contracting partner, the general. He also could bring an unjust enrichment claim against the owner who failed to pay the general, who failed to pay the subcontractor. So in that context, a party could have both a breach of contract claim and be entitled to if it went to trial, could have a judgment against the general for breach of contract and a judgment against the owner for unjust enrichment. That's not in this case. The jury in this case found that the parties had a contract. There's no dispute about that on the verdict form. And in the verdict form, under damages, the verdict form says when the dollar amount, $60,000, it's put the number in for unpaid commissions. It didn't say in the breach of contract verdict form. Unpaid commissions up until the time that Ms. Korshoff was fired. There was no time limit set. There was no this, then possibly that. The unjust enrichment verdict form was not written that way on a temporal argument.
Wasn't the argument presented that way, though, to the jury without objection?
It was, but that in the alternative, though. The argument was, and in the jury instructions, it's clear that the unjust enrichment claim starts off in the alternative. If you find there was not a contract, then you may go through, find if Wesley Financial was unjustly enriched by her services. Also, for unjust enrichment, Your Honors, there was no services provided by Ms. Korshoff after her termination. Everything flowed from her contract. I mean, that's the reason I think that the verdict form was written the way it was. Because like I said, for breach of contract, it said unpaid commissions. There's no end date on that. And the jury put a dollar number on it.
The trial court seemed to look at this counsel as invited error in terms of any sort of ambiguity here is something where there hasn't been essentially that your client didn't do an adequate job of raising these concerns, didn't promptly raise these concerns, didn't timely raise these concerns. Where is the mistake in that analysis?
In the sense of the way that for instance, no directed verdict was filed by the trial counsel. But to raise an inconsistent verdict argument in a motion for new trial, there's no requirement that you had to file a directed verdict motion.
But you would agree another way to do this is to move for directed verdict on the unjust enrichment claim. That would have been another way to handle this.
I will agree with that.
And I appreciate you were not trial counsel. Yeah, okay.
But I agree with that. And back to Your Honor's comment earlier about the language in Tennessee, there has to be no contract between the parties covering the same subject matter. She's selling leads for Wesley Financial. That was her job.
Right.
That's the subject matter.
I mean, the reason why I bring that up is because you put reliance on the Helms against Wells case, and I think that was the circumstance you described in your brief where minor child found, the verdict said nothing for the minor child, but verdict for the parent, and the parent's claim was derivative of the minor child. That seems to me a more stark and clearly inconsistent verdict than what we have here.
In the sense that there were two parties, the two plaintiffs in that case.
Right.
Yes. But there's no case law in Tennessee that covers this kind of situation. There's a myriad of cases in Tennessee on post-termination sales commissions, the entitlement to that. I have not found one that has a breach of contract and an unjust enrichment claim. They all flow, all of the cases that I've reviewed, all of those kind of cases where someone who is a salesperson and got fired and didn't get paid for sales commissions that hadn't accrued yet, came back to, they were derivative of the contract that the person had. There was never an unjust enrichment argument. There was never an unjust enrichment issue brought up by the appellate courts on that issue. This is just simply not I mean, that's the reason that they had to, the appellee in this case, Ms. Korshoff, went to the Sixth Circuit for a Michigan case for the creative argument that they've come up with of, well, the contract ended, so there's no breach of contract damages after that date, but they were unjustly enriched because the sales commissions hadn't accrued yet. They accrued after her termination. The Ulnar case that they've cited is, first of all, it's not dispositive on Tennessee. It's a Michigan state case that went to the Sixth Circuit. If they had found a Tennessee case in support of their argument, no doubt they would have cited one in their brief. They did not. We didn't find a case like that in Tennessee to counter that. It simply has not happened, where a jury can't find simultaneously that both a contract existed, which it did, and that no contract existed, which it did. Those are the diametrically opposing arguments and the issues that came up when the jury came back that are so inconsistent.
Yeah, let me, and I think I know how you're going to respond to this, but I want to get your take on this as well. One of the issues here was what the employee was entitled to commissions to, and was it only timeshare contracts she actually closed, cancellation contracts she actually closed, or what were they ones that fed through her marketing efforts? Correct.
Right.
And so that was one dispute about the scope of the commissions. Couldn't another way besides temporally to reconcile this verdict is, well, yes, we agree that the contract was in fact limited to timeshare cancellation contracts she just closed, but we as a jury are also finding that there was this separate circumstance where she would have been entitled to compensation for her marketing efforts outside the contract, I guess is what I'm saying. Is another way of justifying the two different verdicts here.
But Your Honor, all of her work was centered on doing the same thing. She got $250 for her leads. That was her commission basis, $250 a lead. Some closed before she was fired, and she got paid on. Some may not have been closed. You know, she had pre-termination. Part of her damages, they're not all post. Part of her damage claim, obviously, is for unpaid commissions while she was employed. That's the reason I go back to the verdict form, because the verdict form that the jury said, breach of contract, $60,000, unpaid commissions. And if what the plaintiff intended in this case was for a bright line that breach of contract is going to cover up to the point of termination and unjust enrichment afterwards, they certainly could have written the jury verdict form that way. But the jury came back with two different outcomes that are simply, incompatible under Tennessee law.
Okay, well, your time's up. You have your rebuttal time.
Thank you, Your Honor.
You bet.
Bob Boston. Before I start, I'd like to introduce you to two of the attorneys that have assisted me on the case. They're to my left. This is Quinn-Ann Kibler and David Zeitlin. Ms. Kibler may be familiar.
Is well known to the court, yes, indeed.
But they've never appeared as part of an argument before as well.
We will not penalize you for having brought her with you or anything like that.
If Your Honor please, as I said, it's Bob Boston of the Nashville Bar. I'd like to just start by addressing the court's questions. The first point that was asked the court is, I think the point is, my adversaries assume that the inconsistent verdicts are established by the assumption. We disagree. The only case in Tennessee that they've cited for an inconsistent verdict is the Helms versus Worms case, I think. And it was inconsistent because it was a legal impossibility for the court to have ruled as it did. And it set aside the legal impossibility. In Tennessee, instructions to the trial courts and from the courts of appeals are, you read the jury's verdict consistently if you can. You can here. And that's what was done. The mandate to the trial court is to allow the jury to have an understandable view of the evidence that the parties, and you notice I say both, decided to present and the way they presented it. Here, the way this case transpired over 2 days, every part of it, and look at the record if you would, was by agreement. There was never any objection by the appellant below or here to say, we disagree with the way this is presented. Judge Johnson, in her ruling denying the various relief that the appellants wanted, specifically went through the 10 separate places where the appellant, in her conclusion, and we submit correctly, waived the ability to come in and argue now that somehow the trial court made an error in the way the case was prepared, tried, and presented. Recall, there is nothing in the record that suggests, word one, that the appellant objected to the testimony from Ms. Korshoff on both of the theories, because it didn't happen. There was no suggestion that the agreed jury instructions approved by the court were objected to. And there was no evidence that the appellant put into the record any suggestion to change them or objected to the ones that the plaintiff offered. There was no objection to the specific verdict form. It was agreed, which had both theories outlined. Having said that, the court came to the conclusion, my client would submit it absolutely correctly, that they waived the ability to come in now and argue something different. They never raised a question, either by summary judgment, at a pretrial conference, before the trial started, after the jury ruled, before we left the courtroom, before we went to the parking lot, that there was an inconsistency. It would have been disingenuous for them to do so. If your honors please, that party picked its trial counsel, presumably for his or her acumen, skill, experience, and strategic decisions, every one of which was applied by the trial court, and the jury understood them. On the connection between the two theories, I ask the court, as it considers this appeal, to please look at the two jury instructions on breach of contract and unjust enrichment. The unjust enrichment instruction goes through the elements that my client was required to prove to win on that theory. It goes through them specifically. We had to show 3 elements: a benefit conferred on the appellant, a benefit received by the appellant, and a benefit retained. And the jury found that in that fashion on the claim that related to the post-contract termination. The post-contract termination is important in this case. It allows for a separate theory, properly pled, properly tried, and properly argued. If, in fact, my client had not approached this in 2 different time frames, it is at risk for not getting the second claim before the jury, because the proof was unequivocal that the appellant repudiated, ended the contract. Once it did that, the contract goes away. There is not one. The Oldenar case that we have cited you to, apparently disingenuously because it's the only one we could find, is right on point. The law in Michigan on unjust enrichment has the same elements precisely as the law in Tennessee on unjust enrichment. There's no difference. And the Sixth Circuit, in considering that under Michigan law, which would be the same under Tennessee law, very carefully, very clearly just laid out that if you have a contract that no longer is in existence, you can recover for the same activity temporally, one under breach of contract and the other one later. Now, If you'll indulge me for just a moment, trial exhibit number 3. When I learned this when we were getting the record up here. It's not easy to get a document that's bigger than a regular piece of paper in the record, but it's in there, it's in here. Here it is. This was if you could read it, this is me. I apologize for the handwriting. This was the demonstrative exhibit during Audrey Korshoff's testimony. And look at the first 2 entries. It's set out specifically for leads not paid up until the time she was fired, May the 1st. And then it's picked up after that, temporarily, with leads after she was fired. The reason it was argued this way is for the leads after she was fired, I have no contract for those because they repudiated and terminated and it went away. So we laid it out for the jury so it could decide. If you'll notice, if your honors please, the actual amount of leads that weren't paid post-contract were $400 and something thousand, and the jury awarded less than half of that. That shows that jury understood exactly it was making 2 different determinations, neither of which was prevented under Tennessee law. Contrary to what my adversary says, Tennessee, there are 3 cases that are applicable here to whether or not you can proceed under both theories. One of your honors hit the nail on the head. Generally you don't, but you generally don't go both theories for a specific reason. You don't want double damages. You want separate damages. The fact that damages can arise from different theories for different times is absolutely appropriate. In the case of
Counsel, is it appropriate under the instructions here? And opposing counsel frames the instructions as an alternative. Essentially, underlying case law, these are alternative theories. The instructions, these are alternative theories. If that's wrong, where is that wrong?
Well, it's wrong because that's not what they did at trial, if your honor please. They didn't raise that theory. They didn't raise any question about how this jury instruction or that theory would apply to this proof or that proof. Never has it been raised until you heard it today and in its brief.
So counsel, the instructions aren't going to, going back, reading the instructions of this case, is it going to say you can find contract or you can find unjust enrichment? Or are the instructions going to read to allow for finding both?
It says you can, I don't remember the specific language of them, what they say. It was clear that they are both, you can rely on both in this case. It was, if your honor please, this is an interesting place it puts me in. I'm the only one that was in the trial there. You weren't and they weren't. But I was there when we went through all of the arguments and the presentation of evidence, which is why I emphasize exhibit number 3 that shows the 2 theories were based on a different time frame. Judge Johnson, in her order denying the motion for new trial, she went to great lengths explaining the theory that she thought was going to the jury, that was going to the jury, which were the 2 time frames. I have an analogy, if I can use it, if your honor please, that I think further explains the point. Assume that my client is a farmer, and assume that she goes to work for landowner Appellant to plant, fertilize, water, till, weed, and harvest a field of corn. And assume every one of those ears of corn is worth $250 while she's employed. That's her contract. That's what I get. And I get a salary and an ear of corn commission. She's fired. She's fired after some ears of corn have matured and been picked. That's pre-termination. But after that time, she no longer has her contract because there's no corn then ready to be picked. It comes afterwards. So she picks up and says, at this point, the work that I have done, which is to the benefit of the appellant, is in the field, and it will mature, and lo and behold, in this case, it does. And when it matures, she's entitled to unjust enrichment damages, which aren't her salary and commission. The jury found she was entitled to unjust enrichment damages, which were less than the $250 per ear of corn. If you look at the math, the damages that we wanted were $400,000, just taking the math times the number of prospects. They didn't give her that. They gave her the damages under the instruction on unjust enrichment, which are the value of the benefit received for the services rendered. That's what she got under the second theory. There is no clearer way to explain it other than to look at it the way it was presented and tried, which the jury verdict allowed, and which allowed under Tennessee law the judge to apply the judgment. Never during trial, never until new counsel got involved and looked at it, was there little finger raised by the appellant that that was wrong or inappropriate or somehow not consistent with Tennessee law, and most importantly, wasn't clearly the jury's expression. If your honors please, what is glaringly omitted from any argument you've heard, and I say this with respect to great lawyers who are friends, was any recognition that that appellant stole my client's money. To this day, it has not been paid. It is wage theft, as the court said below. The jury lit them up for it. The only injustice here, and I say it respectfully to our legislature and our Supreme Court, is that there is a cap in Tennessee, at least by argument, that I haven't raised on appeal, on the amount of punitive damages. If you'll recall from this record, there is 3 places that the court found, and it was established unequivocally by the proof, that this was a repeated act by that employer. 2 different people had been fired when they raised questions about their wages. A class action was filed against the same employer for taking other people's money. And the record reflects, in passing, that even Ms. Korshoff's daughter had her money taken for her for 2 weekends of work. The justice that the jury applied is consistent with Tennessee law on the underlying theories. They are not inconsistent verdicts when the courts in Tennessee are required to read them together if you can. And not only if you can, they are.
Can you address the 13th juror argument
Yes, sir.
here and the
Thank you for asking the question.
trial court's role? There was some commentary made here, and I'm not sure that's way I understand the role of the 13th juror. I mean, what do we do with that?
Okay, so the 13th juror relates only to the retaliatory discharge claim.
Correct.
It's one of the 3 claims that the jury ruled in my client's favor. After the trial was over, by the way, when that was raised at the trial court below.
Yeah, and let me preface my question with this. I know that you're saying, in effect, in your briefing, well, that's another flavor of sufficiency of the evidence. Let's say we don't buy that.
All right.
Let's say we don't buy that. We say, no, we need to figure out what's going on with these comments here. What do we do with them?
Okay, thank you for the clarification. That would be the first argument. But if you'll notice in the briefing that they raised on the challenge to Judge Johnson not acting appropriately as 13th juror, they cite to the fact that they say, she said, the jury believed this proof. That's not what she said. That's part of what she said, and we noted this in a footnote, I think on page 41, footnote 7, I don't remember exactly, but we pointed out that she said that the plaintiff showed the elements of retaliatory discharge. And she went on, Judge McBrayer, if you'll notice the last thing that Judge Johnson says in her order, she says, Audrey Korshoff was not paid. She challenged the fact that she was not paid. And she was retaliatorily discharged because of that. I'm paraphrasing. That is an unequivocal expression that she is agreeing with the jury's verdict. She could not have been more definitive of it. There is no suggestion she did not understand. There is no suggestion that she would have said, I could go either way, which is what the one case says that they cited. It is an unequivocal expression that they proved, my client proved, that theory. She perfectly acted as 13th juror. Our time is up, and I thank you for listening to my client's argument.
Thank you.
Let me start by addressing the raising of corn example that Appellee counsel has raised. In that example, all of the plaintiff's work was finished when she was fired. No additional services were performed, no additional work was performed beyond that in the worker's contract. That is precisely what this case is about. Ms. Korshoff did no further work. Everything that was asked of her to do under her contract at the time that she was fired was finished. Everything flows from her contract. The case that was cited by the trial court and the Michigan case, the Olnar case, that Appellee counsel discussed with your honors. In that case, one important difference from this case, that case addressed situations in which services were provided after a contract had expired. Completely in opposite to this case. Here, the services at issue all occurred prior to Audrey Korshoff being terminated. The fact that some of them didn't accrue until after her employment had been terminated doesn't change the fact that her claim to those commissions flowed from her contract.
Counsel, do you disagree with opposing counsel's framing of this case as the case was presented to the jury as having this temporal divide? Pre-termination, it's a contract matter. Post-termination, it's an unjust enrichment matter, and that it was presented to the jury that way without any objection from Wesley. Do you disagree with that characterization?
No, I cannot disagree that trial counsel did not raise objections to a number of things, Your Honor. I cannot. I will say, though, that when Your Honors take a look at the jury charge, the jury instructions, which the jury has to rely on, has to use hand in glove when rendering its verdict. Because the verdict form references by page number on breach of contract. Take a look at pages this of the jury instructions. On unjust enrichment, the same thing. And when Your Honors look at the jury charge on unjust enrichment, which is right here, it is clear. It says each plaintiff has also asserted an alternative claim to breach of contract. If you do not find that either plaintiff had a valid contract, you may still find Wesley was unjustly enriched. There is no, well, you can get both at once. Both simultaneously. The premise of this unjust enrichment charge is right up front in the first 4 lines.
I believe your time is up.
Thank you, Your
Thank you. Thank you both.